Hey, good morning, everybody. Welcome back to Law and Legitimacy. It's Tuesday, day 2 of People of New York versus Donald J. Trump. Well, my great prediction. And good morning, Michael. How are things down there in North Carolina?
Great, Norm. Okay, I have a question for you to start this off. Curveball. Who's your favorite instructor on the Peloton?
I don't use the workouts. I do the challenges and internal rides, and so I don't use the instructors. There's a guy from Britain that I've used from time to time. I like him. Some of the women are challenging, but I say I don't use them, and I think back to having used them. But I just like to ride and, just keep, I'm not fit right now in the way that you are, in the way that I have been in the past. I just try to get on there and burn some stress and burn some calories and keep that ticker talking, because I'm going to need it for a while more, I suspect.
Heard that. Well, I was just, at some point I'll get on my soapbox about the complete bot that is Olivia Amato, but we can move on. Good morning.
I mean, the problem I have, is mediated relationships with electronic images. The fact is that you and I have met but once. I mean, you came up to New Haven and I showed you and Cam around. And we have this electronic relationship, which is satisfying, and our listeners find and viewers find these relationships satisfying. But our primary relations, I think, are with real flesh and blood people, and the significance of touch cannot be overstated. I can't help but wonder whether so much of what's wrong with the world now is that our primary relationships are with electronic images and not with others. And the result of that is that we are not fully accountable for our reaction to people in our own skin. I sat down with somebody yesterday to talk to him about some deeply personal stuff, and we met personally rather than online. And so much of the communication involved a nuanced interpretation of ambiguous expressions and the ability to read another person empathically in their presence and their reaction to what you're saying. Is a skill, and it's an important skill, which is why we have children, and why we have significant others in our lives. So it is what it is. But welcome back, everybody. This is our mediated electronic world. I finished yesterday.
It's funny that you say that, Norm. I don't know if I sort of incepted that notion.
Incepted, another new word there. Neologism work. Neologism work.
Telling you about my conversation with one of the younger employees of a different business of mine over the weekend, and how struck I was by this really, the recognition that younger people are becoming more and more sort of, I think, puritanical, right? But I think the key distinction in our time is that most young people know each other virtually primarily, and rarely in person to the same degree that they're interacting with people online, right? In such volume. So that's interesting that you're saying that. I think that's that's a problem.
I think it's gotta have an impact on how we get along, and it has to in part explain the craziness of our times. I finished yesterday. I finished yesterday the first American history in the 4 that I told everybody I intended to read back when I was writing, and he ended talking about the impact of the internet and electronic communications on the world. And I just don't think it's any mystery that our politics has gone into the pooper at the same time that shortly after the pandemic, where we were forced to lose our human connection one with another and react to the avatars that we become online. I mean, even now, as you and I speak, we can be as candid and open with one another as we can, but our bat sense, that sense that we have of connection with others. I'm looking at an image of you, and what's bouncing back is something that is devoid of human contact. I can't smell you. I can't sense you. And I think that we are sensual things, and the significance of touch cannot be overwhelmed. And you can't touch an avatar. You can't touch someone through the screen. Significant stuff, stuff worth thinking about, stuff worthy of thinking about by social psychologists and psychoanalysts and so forth who have training that we don't. We, on the contrary, are just a couple of humble lawyers. You from North Carolina, me from New Haven, wandering and rambling around our days, trying to make sense of it all with people online and trying to offer a different perspective because the partisanship and divides in the world don't work. And, so let's take a look at a highly partisan event, and that is the Donald Trump trial. So, I was wrought yesterday. I felt that we had come to the end of a moment, and that Judge Merchan's decision as to the people of New York's contempt citation, inevitable contempt motion against Donald Trump was going to be a defining moment in American politics. And I said that. And then I watched the day unfold as I wandered around from commitment to commitment, writing briefs and dealing with personal issues. And I realized, wow, did I get that wrong? I mean, Judge Merchan and the people of New York may have found a way to duck that issue. The people are seeking only a $3,000 contempt fine as to Trump, $1,000 for each of 3 utterances that they say are in violation of the gag order. Merchan's going to hear argument apparently on it and make a decision next week. But if he just did, $1,000 fine, that sort of, acknowledges the moment, tokenizes it. It's the functional equivalent of about 6 cents for the rest of us to Donald Trump. He pays it and moves on. I think the people of New York are trying to defuse this situation to keep the trial on track. And they have to realize that sanction is meaningless. That holding Donald Trump in contempt is like telling a fat person that they eat too much ice cream. Yeah, so what? Give me another bowl. And Donald Trump is in contempt of the contemporary norms, and he's in contempt of the process because he regards it as fundamentally political. And when I look at some of the questions, I want to pull up my iPhone here. When I look at some of the questions that was put to jurors yesterday, I can't say that he's all wrong. So apparently 500 people were summoned yesterday to Manhattan. Several hundred of them made the preliminary cut. In other words, they didn't answer questions in such a way as to be immediately disqualified. And so for those of you who don't pick juries for a living and wonder what the hell it is we're talking about right now, let me tell you what jury selection is in the criminal justice process. In the United States, people are presumed innocent. That is, yeah, that is, although the government can.
How quaint, Norm! How quaint that there is a.
You say it's quaint, Mike, but I will fight like an animal to vindicate that presumption in any case, in any day where I walk into a courtroom, because my view is when people walk into a criminal courtroom and they see state of North Carolina versus Michael Boyer, their first instinct is, what did Mike do? Why is he sitting there? That is a wrong instinct. It needs immediately to be reframed. Because that question sacrifices the presumption of innocence to a presumption that there must be something to the state's allegations. The primary question in a criminal case, and I think practicing lawyers take note, when you walk into a courtroom, you need to reframe the issue automatically. And so one question I have asked of potential jurors, because you're looking for a fair and impartial jury that can apply the law. And so, my first question is typically, how did you feel when you got your jury summons? Did your reaction to jury service change when you learned that you might be considered for a criminal case? You've heard the charges. How do those charges make you feel? Now, as you look at my client right now, if the judge were to tell you what's your vote, guilty or not guilty, how would you vote? And many people say they can't vote. And I say, how is that possible? You saw a film this morning that oriented you to legal principles. Yes. And the presumption of innocence means that unless and until the state proves its case beyond a reasonable doubt, you're required to vote not guilty. Could you follow that instruction? Yes. Can you see how if you followed that instruction now, your vote right now would have to be not guilty? And it's because you've heard no evidence. So do you understand, and I'll say this to a juror, do you understand that in a criminal case, you're not here to sit in judgment of the defendant. You're here to sit in judgment of the state. The state has made allegations against my client, And it's the state's obligation under law to prove those if they can to your satisfaction beyond a reasonable doubt. In the absence of that, you must vote not guilty. Could you follow that instruction? And if you can't, you're off the jury. And famously, Ned Lamont, the current governor of Connecticut, was once a panelist, a voir dire panelist in a attempted murder case I tried in Norwalk, Connecticut, maybe 20 years ago, and he couldn't answer those questions to anyone's satisfaction. So the governor of Connecticut couldn't follow the instructions, had no ability to apply the presumption of innocence, and was excused from the case for cause. That's the way it goes. So in the Trump case, here he is charged with this hush money thing with respect to Stormy Daniels. Apparently he put the ass in assignation and had a meeting with her where certain libidinal sparks flew. Didn't want it to come up in the campaign, and instructed Michael Cohen to pay her money for an NDA, a non-disclosure agreement, hush money. Cohen allegedly used a personal line of credit to pay $130,000 to Stormy, and then Donald apparently repaid him. And in their public filings, they were not truthful about the purpose of those payments, and so the state of New York is charging them with filing fraudulent public documents about this, and that's the trial. Now, really, you're going to charge somebody with that? This is probably a routine practice in many businesses. That's why people sign confidentiality agreements when they settle lawsuits. If you're publicly reporting them, you're not going to say, "Oh, I did an NDA to keep my indiscretions from becoming public view." That would sort of violate the NDA right there. And, I'm not sure that this is really the best use of the people of New York's criminal resources. And you begin to think with Donald,
in particular, because this is the first time that this has ever been enhanced to felonious conduct, right? And
because of its impact on an election. And so, Mark Pomerantz, you see that he wrote a fascinating book about this. That's in the second question. Have you read or listened to audio of any of the following books or podcasts by Michael Cohen or Mark Pomerantz? I think we talked about the Pomerantz book a couple of years ago when I read it. I don't remember, frankly, if we did or not. The geriatric moment here. But it's the third question in this voir dire that kind of torques me off. And I'm not saying this is the third question that they were asked. In voir dire, VOIRDIRE, to speak the truth. That is how jurors are vetted. Voir dire, as they say out west. Voir dire, or voir dire, as you say in the East. And the purpose of voir dire is to present jurors with potential issues and themes or information that might flush out their biases, because your goal is to get a group of jurors who can fairly and impartially consider the evidence in a case. So why is this question asked? Have you ever considered yourself a supporter or belong to any of the following: QAnon, Proud Boys, Oath Keepers, Three Percenters, Boogaloo? What does that have to do with whether Donald Trump submitted false information to a public agency?
Amazing.
To me, this question highlights the quasi, and I'm not with the Donald on this one, at least not yet. But this question highlights the quasi political nature of this case. I mean, you're really going to ask a juror who's being asked to determine whether fraudulent papers were filed, whether they were a member of or supported QAnon, the Proud Boys,
by mere association, right? By exercising your First Amendment right to freedom of association with certain groups, and if you are willing to, and again, you're not permitted to lie. Candor is required in these circumstances, right? Otherwise, I could go to a mistrial. Say, for example, somebody denied involvement with the Proud Boys or the Oath Keepers, Three Percenters, Boogaloo, respectively, and then it later came out during the course of the trial that one or more of the jurors lied or covered that up. That would be grounds for a mistrial, right? But I think the issue here is that are jurors now sitting in judgment by mere association? In other words, are jurors tainted? Right? And is their ability to answer the question that you posed at the beginning of this stream tainted because they would have otherwise put themselves in a social situation with any of those named organizations, right? And then to the bigger point, because I think that we're going to talk about the January 6th obstruction case that's, United States v. Fisher, right? But I think aside from that, right, what, again, to your point, Norm, what does this question have to do, or what does it bring to bear about the nature of this case, like the underlying foundations of this case?
Well, I mean, so the questions are designed to determine bias that people may have. And so the assumption has to be that if you're QAnon, you support Trump. If you're a Proud Boys, you support Trump. If you're an Oath Keeper, you support Trump. If you're a 3%er and Boogaloo and so forth. And therefore, this is a marker for bias. So if a person says yes, I wouldn't say they're automatically disqualified. That may be I'm sure this was a question proposed by the prosecution. And their assumption is that anybody answering yes to this question is going to be disqualified for cause because they are a Trump supporter. So the follow-up defense question would be, sir, I see that you said you supported the Proud Boys. Does that mean that you are inclined to believe anything Donald Trump says? Does that mean you've reached an independent judgment about this case? Do you believe that just because you feel, could you be fair and impartial and decide the evidence based solely on the evidence presented in this case and not out of any pre-existing attitude for or against Donald Trump? And I suspect a significant number of people who supported these groups could answer that they could follow the case. So, I mean, here, for example, I represented the Proud Boys in the seditious conspiracy trial in Washington, D.C. last year, a 5.5-month trial. I have strong feelings about my clients, and I don't believe that the government actually proved the crime for which these fellows were convicted. And eventually I'll get around to writing an appeal for them, and off we'll go. I mean, I represent two of them, Zach Rell and Joe Biggs. It's not all of them. But even I could say, notwithstanding my support of them at trial, notwithstanding the blood, sweat, and tears that I put into that trial, I could decide whether Donald Trump engaged in fraud or not. And, I'm large enough in soul and in spirit to put aside my commitment to those clients, my commitment to that fight. And mind you, it was a brutal fight. I mean, those of you who aren't trial lawyers may not appreciate it. Those of you who are, put yourself in Washington, D.C. for a 90-day trial, away from home, away from your office, away from family, away from friends, in the pressure cooker of sometimes 16, 18, 19, 20-hour days. Not that I lived those. I went to bed early and let other lawyers deal with the overnight
we streamed through it, right? Hashtag stream through it.
Yeah. Well, I guess we did. And, you'll make your own observations about its effect. I certainly found it stressful, but the mere affiliation with that group doesn't affect how I would evaluate this conduct. And so it seems to me that that's the government, the state of New York, tipping its hand a little bit about this as a political prosecution, because they've concluded that if you're a member of a certain group, you can't be fair and impartial. And isn't that Donald's point? That this is a political prosecution and they're trying to isolate him for political reasons. And, I can't say he's wrong. So,
and that's sort of there is no limiting principle, right? It just goes one way. So Dawn says, how about the question, do you ever listen to NPR? And Janet follows up by saying, do you watch The View? Right. And that's the point. But that's the point, right? Is that those aren't on there. And then, your affiliation. And again, the response would be, they weren't charged with seditious conspiracy and overthrowing the Capitol, right? Whatever. That doesn't get at the heart of this. What do you make of Judge Merchan? I'm seeing reports, and I'm going to put something on the screen here from a reporter for The Guardian. His name is Hugo Lowell. He says, Judge Merchan in Trump criminal trial appears eager to get onto the voir dire jury selection process. Trump lawyer Todd Blanche says Trump intends to be present for everything, including sidebars, which is now causing a new problem because logistics issues with the U.S. Secret Service. President Trump wants to be present at everything, Blanche insists. Judge Merchan warns Trump that if he disrupts the proceeding, he could be jailed with jury selection continuing in his absence. It's a routine Parker warning that Judge Merchan issues. Manhattan DA prosecutor Conroy now asked Judge Merchan to find Trump in contempt for violating the gag order, $3,000 because of 3 instances where Trump attacked potential witnesses. Conroy adds Trump may have violated it again this morning from court. The prosecutor warns Trump to delete the posts on Truth Social, April 10th repost on Stormy Daniels and Michael Cohen, and another post on Daniels and another post on Cohen, and be told that further violations will result in jail time. Now, my question is simply this. I've seen reports that Judge Merchan has mandated that Trump be present for every component of these proceedings, and the narrative being run with in the conservative or more politically right circles right now is that Trump is going to be forced to miss his son Barron's graduation because of this. He won't be able to attend graduation because Judge Merchan intends for him to actually be here. My question is not so much about missing his son's graduation. That's ridiculous. But it's more about his status as front runner for the November election, right? President of the United States. If he is required to be at every component part of this proceeding, what does that mean in terms of his ability to actually campaign? And
I would like to reframe this. I think Judge Merchan is full of feces on this, frankly. A criminal defendant has a right to attend his trial, a constitutional right, and to be present at every critical stage of the proceeding. Now, his questions to be present at sidebars, some judges permit it, some judges don't. And I don't know that the case law is absolutely clear on whether a person has a constitutional right to be present at their sidebar. I've had clients who have been brought up to sidebars so that they could listen. And I have argued from time to time that being present at every critical stage of the proceeding means being present during sidebars, because often dispositive, meaning case deciding issues, are decided there. And you have a sidebar because you don't want the jury to hear what's being discussed, but you don't have a sidebar to exclude the defendant. So I thought this was a little bit of unnecessary and stupid chest thumping by Judge Merchan. He doesn't have, clients can waive by misconduct their right to attend their own trial. If he acts up, that's not going to stop the trial, notwithstanding his waiver. Now, if he acts up and is taken out of the courtroom and held in the lockup because he won't let the trial proceed, he will be deemed to have waived his right to be present at a critical stage of the proceeding by misconduct. That is clear. And so if you can waive it by misconduct, I don't know why you can't waive it necessarily by a canvas, by the judge saying, by you're saying to the judge, I understand that it is my right to be present at the critical stage of the proceeding, and I am willing to waive that right in the same way that I would be willing to waive my right to a trial, to waive my right to testify. People are canvassed about these things all the time. So this also supports the notion that this is sort of political in orientation by Merchan. I've told regular listeners, no, I've appeared before Judge Merchan in the Manhattan Madam or Soccer Mom Madam case of Anna Christina. Geez, I don't know, 15 years ago. Merchan is not a dumbbell. He's also a peacock. He likes being at the center of attention. In this case, he broke his wrist, thumping his own chest. This was a stupid comment by Judge Merchan. It plays right into to Donald Trump's hands. Trump, if he can waive by misconduct his right to be present, the trial can go forward. He should have the right to waive deliberately his right to be present at every critical stage of the proceedings. Judge Merchan in the state doesn't have a right to rub someone's nose in their allegations against them. And so stay tuned. So we'll see how it unfolds.
On this, I'm looking at the clock and I'm making sure that we have some time.
Yeah, let's shift. Big arguments in the United States Supreme Court today. It is in the so-called Fisher case. Jake Lang's involved in that as well. We filed a petition for certiorari, that is to ask the United States Supreme Court to rule on whether a Sarbanes-Oxley obstruction of justice statute was even applicable to the January 6th riots at all. This is the issue of 18 United States Code Section 1512, which makes it a felony of up to 20 years to obstruct an official proceeding. There are several prongs in the statute. The first says, if you screw around with some paper or intimidate a witness, you're in a lot of trouble. And then there's a section that says, or otherwise corruptly obstructs with an official proceeding. Did Congress ever really intend this statute to stretch so broadly as to cover the rioters' conduct? The Supreme Court will hear that case. We filed a petition for Jake Lang for certiorari. Fisher's lawyers filed a petition. There was a petition filed on behalf of a third. Both my feelings were hurt when the court granted somebody else's petition and deferred action on ours. but I understand the reason for it. They chose a seasoned law professor and someone well known to themselves to brief and argue the case today as they will argue it. And they neglected to give me the honor, right, and privilege of doing that. So shame on them. But frankly, I'm glad I didn't have the stress and pressure of doing that today. So the argument has enormous consequences for the J6 prosecutions and prosecutions going forward. If the court holds that 1512 is an overbroad application, or maybe even a vague application of this statute to the defendants, and vacates the convictions on those grounds, it could be that there will be resentencings for all of those who were convicted of a 1512 count. Whether those resentencings will result in practical relief for the defendants depends on the sentence itself. So suppose you were sentenced to 10 years for a 1512 count and 10 years for another count, and those sentences ran at the same time, or as we say in the trade, ran concurrently. Vacate the 1512 count, and you're still facing 10 on another sentence. And so what's the issue? Those who have entered pleas where the 1512 count was used as a hammer. If you take 6 years on this count, we will not pursue the 1512 count, which carries up to 20. Those people are in a lot better position if 1512 is vacated. And so, we won't know, obviously, what the court's decision will be on this, probably until June. The court will soon stop hearing arguments, and we're about ready to get into fat season, as it were, in the Supreme Court calendar, where decisions are made seriatim, and often decisions with huge consequences going forward for a number of people. The Fisher decision, related to the Jake Lang case, and the third case, again, the name still escapes me. This decision will come out in June and will send ripples throughout the J6 world, and I'm looking forward to it.
Rocky says void for vagueness, and the reference is obviously to the plain language. I'm going to put it back on the screen here, Norm, and I put on the screen in the notes there that it's an Enron era federal statute, and you referenced Sarbanes-Oxley, and so I guess I'm wondering here. You and I have talked about this a lot, and you have given very thorough thoughts on the use of this by the DOJ at the time that it was happening, and of course you were active in filing the Lang cert petition, and I wish
I wasn't active. I filed it.
Yeah. I was hoping that they would just take that one. But no one likes Norm. So, but I'm looking just at the plain language of this, and the term official proceeding is obvious. It's defined, but I think that when we put it in context of Sarbanes-Oxley Enron era legislation, we're talking about financial crimes and sort of what would be considered like white collar fraud, right? It's amazing that this has been sort of the main weapon wielded against those present at the Capitol on January 6, 2021. No, this isn't a statute that at any point contemplated a situation like we saw, and yet it's being used in that way in hundreds and hundreds of cases, right?
Yeah, no, I mean, the J6 prosecutions are particularly troubling, in part because political speech was used as evidence of corrupt intent. Here, dancing around on the lawn saying 1776, death to traitors, and then you cross a line and go on to Capitol grounds. Does that mean that your political speech is evidence of criminal intent, or does it mean that you were engaged in protected speech and then you acted against the law? And so in the Proud Boys appeal that I'll be taking on behalf of Joe Biggs and Zach Rell, we're going to ask the appellate courts and ultimately the United States Supreme Court to adopt a test, much like the test used to determine whether statements of co-conspirators are admissible. You've got to do more than say that a person said something. You've got to have some, and I don't know what that standard is. I'm still struggling with it. We want to make sure that the court gives adequate protection to dissent and to political speech, because that is the core foundation of the First Amendment. And it seems to me that there has to be something more than that. You said on Tuesday, death to tyrants, and on Wednesday, disrupted an official proceeding. That there has to be more than contiguity in space and time. That is a relationship in space and time between these two events to make one circumstantial evidence of activity on the other day. And I still don't have the secret sauce answer to that. Those of you lawyers listening to this, send me a private note. I've been reading cases and law review articles around the country trying to find something there, and it's hard work.
Well, and there's no doubt about that. What strikes me about that conversation is that it's not altogether surprising to me that this is where we are in the procedural history of these criminal prosecutions and convictions. And I think that what I've known and what we've discussed before, and many people, their sort of visceral reaction to the way the DOJ has been inarguably weaponized against a certain political class in the U.S. Um, it 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 gives more credence, more credibility, more meat on the bone, if you will, to the notion that justice delayed, right, is the whole strategy. That the unprecedented wielding of certain legal tools, such as 1512, in the way that it's been wielded, was never designed to stick long term. And perhaps there was some knowledge on the part of the Department of Justice that it would be undone in time, but that for this period of time, it would chill the freedom of speech, the freedom of association. It would chill sort of the organization and the populist pushback to what is clearly a rejection of an illegitimate presence at the federal level. And, you know, to your point, I think that so few people actually hear you say that the convictions for this seditious conspiracy in the Proud Boys case, namely Biggs, Rail, and the others, is frightening because there was no overt act in furtherance of the conspiracy, right? There was no, well, the overt act, sorry, misspoke. There was an implied conspiracy argued at trial.
Right. And that's the terrifying part.
Yeah, the government argued to the jury that they could find that a conspiracy existed by mere implication. In other words, no explicit organization, that it occurred instantaneously on the day, that there was an instantaneous conspiracy. And that's what the convictions settled on top of, right?
So I'm looking at the comment here. Norm, are you publishing real-time details of the Biggs trial? That trial was a year ago, Julian. Help me understand your comment. I mean, I know that space and time are relative, and there are those who think we can do time machines, but I can't do a real-time thing about something that's more than a year old. What are you talking about, buddy? Give me the translation from down under.
And in the crowd said, I didn't know Sarbanes-Oxley spanned that far. My experience with SOX compliance in the financial realm is different, as I'm someone from a public company. This is new to me. I'm definitely intrigued. But I think that's the point that I'm making, right? Is that, you know, it was formed, and the legislative intent was in the context of the Enron scandal, right? And Sarbanes-Oxley, as a piece of legislation, was informed and passed and ratified with that specific intent to give the government the tools necessary to prosecute those indulging white-collar crime. This is as far from white-collar crime as it gets.
That be the case. Let's see if we've got a comment from Julian. Otherwise, let's just move on. We've taken some time. Oh,
he said, I thought you had upcoming J6 cases.
I do have another upcoming J6 case involving.
What is this about, Norm? Look at the comment on the screen. What's that about?
There were hidden files. Have those been released? No. So during the, and I think I understand the question, Ted. I think you're referring to confidential human sources. In the Proud Boys case, there's another possibility. In the Proud Boys case, we pushed the government to give us information about confidential human sources embedded with the Proud Boys on or about January 6th. My theory was that if these confidential sources didn't hear anything about a plan, then there was no plan. We were given information, and it's under seal. There were occasions in which the government, in which the court closed the courtroom to the public, and we had proceedings that remain under seal. So I can tell you that there were confidential human sources embedded within the Proud Boys. We don't know how many. We never got a straight answer. We know that there were at least 8. We know that other agencies had agents on the ground. I'm unaware of any evidence that suggests these people caused January 6th or entrapped others to do things. And there is a highly fractious and rich debate about this among those following these cases. I only know what I saw, and I'm not going to follow evidence that I didn't see with my own eyes, because I think the world is bat feces crazy, and I don't want to contribute to the craziness. The other thing, though, Ted, on hidden files, Nick Smith, a lawyer from New York, did a wonderful job cross-examining an agent and learned that there were some, frankly, classified information embedded in the discovery given to us. And when he started to cross-examine an FBI agent on that, we had another set of sealed proceedings. And so I don't know that those have been released to the public. I think that to the degree that we debated about the meaning of those files, none of them, in my opinion, were so prejudicial as to affect the fairness of the trial. And I don't think that they are grounds for appellate review. Reasonable minds may differ. And when we read Nick Smith's brief on behalf of Ethan Nordine, if he thinks differently, I'm sure we'll see it. And to give credit to Nick where credit is due, he did the primary work on the Fisher case. And so the case that's being argued today is largely as a result of his briefing. Very talented young lawyer. A shout out to Nick Smith. He's in his 30s in New York.
Your position on that doesn't foreclose the observation, and we made that at the time on the stream. Like I said, we streamed through your entire stay there in DC during the trial, and I think what was striking about that was your revelation, your personal revelation, that there was no way to know how the administration of the confidential informants program was actually managed, whether there was some sort of hierarchical structure. And that was the nature of those sealed proceedings, is that you guys were trying really aggressively to understand the breadth and scope of a CI presence on J6, and how the federal government was actually managing who and how they were managing that program, and how it may have affected that case.
There are still books to be written on the J6 prosecutions, and still trials to be had, and still many, many questions to answer. I think that the House and Jim Johnson or Jim Jordan and others have really done a half-assed job unearthing what the government has been doing with respect to dissent in our time. I think that this is time for another look into the intelligence agencies, similar to what the Church Committee did in the 70s. When it learned about CIA involvement in assassinations of foreign leaders, harassment of dissent on the left in the United States. Fundamental questions remain to be asked. And frankly, there's just too much chest thumping and dumpster diving at any camera that is pointed in their direction for these people to do any thoughtful and meaningful work, and shame on them. Yeah. So.
Well said, Norm. And I obviously agree with that. Dawn even offers up that she's disturbed that Trump is becoming increasingly self-centered in his criticisms of the justice system. Little mention of other like lawyers and supporters who are in jail, getting disbarred, etc.
There's a newsflash, Dawn. Trump, self-centered, narcissist in bloom. It's all about me.
Lord of mercy. All right. Well, look, Norm, we've done it again. We didn't get to the Abbott story. I do want to save that for tomorrow. I sent you a piece from the American Conservative. Query is Abbott a mastermind for the executive order banning anti-Semitic hate speech on college campuses in Texas? We'll talk about that tomorrow. I have a view on that, and it folds into our expectation here that there will eventually be federal precedent for the creation of a hate speech exception to the First Amendment. So that's all I'll say for now. Norm, thank you. You can find us here every weekday morning, 8 a.m. Eastern Time, on Rumble, on X, and on YouTube at Law Pod Daily. Again, I want to thank all of the new subscribers, and I also want to acknowledge and thank all of the OGs that are with us every single morning. Many of you have been around for going on 2-3 years now, and were with us through the J6 trial that Norm was in DC for. So thank you, and continue liking and sharing these streams. Comment. The comments have been great feedback as well. So
yeah,
Norm?
Spread the word. We'd like to develop a financial infrastructure that permits us to spend more time on this. Both of us. Mike has a family to raise. I have people to support, including a large firm. And to the degree that we can generate financial support to spend more time on this, the quality of the programming will improve. But it's going to take we've just begun to monetize this. We hit the critical threshold thanks to the support of Eric Huntley and others, and now we need you to spread the word If you like this content and you think it's helped change your perspective, or at least help you walk a little more solidly in this crazy world of ours, spread the content with others. We know we're onto something. You do too. So on that note, I'm off to prison to do some visits today. I hope they let me out. I don't know why it is people are using fentanyl. I don't know why it is people are trying to make a buck at it. And I don't know why it is so many of my clients are involved in distributing fentanyl. I think I'll find out today. AMF, yo-yos.
AMF, yo-yo. Adios. See you tomorrow.
Adios.